Welcome to the Supreme Court of the United Kingdom, where today we are hearing an appeal in the case of the Queen on the application of Highbury Poultry Farm Produce Limited and the Crown Prosecution Service. Details of the case can be found on our website by following the link to cases and then to current cases. The court hearing this appeal comprises, besides myself, 4 of my colleagues, whom I'll introduce now. First, Lord Lloyd-Jones.
Morning.
Lord Kitchen.
Good morning.
Lord Hamblin. Lord Hamblin. And Lord Burrows.
Good morning.
The parties are represented by Stephen Hockman, Queen's Counsel, and David Hercock, appearing for the appellant, and David Perry, Queen's Counsel, and Victoria Ailes, appearing for the respondent. I'll now invite Mr. Hockman to begin his submissions.
Thank you. Thank you very much, my lord, and good morning to one and all. I hope I can be clearly heard, and I'm sure someone will indicate to me if there's any problem with that. As the court is aware, the appellant company operates a poultry slaughterhouse in Shropshire. The average throughput at the plant is some 75,000 chickens per day, or nearly 20 million a year. And the chickens are shackled to a moving line, then stunned so that they become unconscious, and then their necks are cut, bringing life to an end. The allegation in this case is that the neck was not properly cut and that the process continued while the chicken was still alive. It's to be noted, firstly, that no prosecution has been brought against any individual operative, and no allegation is made of any systems failure, such as a failure in training or supervision. The case for the appellant is summarized in the appellant's written case, paragraph 15, which is at electronic bundle page E79. And if it's convenient, I will hereafter give those page numbers simply as E79. And there are 3 points. First, on a correct interpretation of the relevant EU regulation 1099 of 2009, a business operator cannot be in breach of the requirements of that regulation in the absence of intentional negligence on the part of the business operator. Liability for a contravention of a provision in the regulation is dependent upon proof of intention or negligence on the part of the business operator. That's the first point, which we could perhaps call the EU point. Secondly, on a correct interpretation of the statutory offence in Regulation 31G of the national regulations, the welfare of animals at the time of killing regulations, sometimes called the weight-off regulations, criminal liability for a contravention of a provision in those regulations, for a provision in the European regulations, requires proof of mens rea and or negligence on the part of the business operator. And that we could perhaps call the mens rea point. Thirdly, the legislation is concerned with the question of direct liability for personal conduct. The acts or omissions of an operative cannot simply be attributed to the business operator. Regardless of mens rea or negligence, a culpable act or omission must still be proved against the business operator. And that we could perhaps, for simplicity, call the attribution point. So we have the EU point, the mens rea point, and the attribution point. I think I'm right in saying that for my purposes, it would be sufficient to succeed on any one of those points. And I suppose if I'm right about that, it follows that my learned friend, Mr. Perry, in order for him to succeed, would have to achieve success on each and every one of the 3 points. Contrary to
Mr. Hockman, forgive me.
Yes.
I wonder if it's right that you in fact have more than one bite at the cherry on your submissions 1 and 2, because if it is the case that EU law requires the imposition of a strict liability, is it open to the domestic regulation to depart from that?
Very much so, my lord. That's a point that I shall deal with in some detail when I come to the domestic regulations. But on established EU jurisprudence, it is not necessary for national law in laying down or in providing for criminal offences. It's not even necessary for national law to provide for criminal penalties. But if it does provide for criminal penalties, it's certainly not necessary for national law to provide that there shall be strict liability on the part of the operator. That we submit is a clear principle, and it's for that reason that we suggest that points 2 and 3 have to be dealt with separately from point 1.
And you say that, so do you, even if the liability under national law is a lower standard than that required under EU law?
Well, I don't know about a lower standard. I wouldn't necessarily use those words with respect, but I do say that even if your lordships were to be against me on the EU point and to hold contrary to our case, of which I hope to persuade you, but if you hold contrary to our case that liability under EU law, to use shorthand, is strict, it is still not only open to you, but appropriate and necessary for the court to find that liability under national law, under domestic law, is not strict, and that mens rea or at least negligence, a lack of care, are required as elements of proof. And then thirdly, that in any case, again under national law, the principle of attribution is relevant, and the prosecution have to prove that the acts or omissions of the operative can be attributed, can properly and lawfully be attributed to the business operator.
Thank you very much.
Under the EU regulations, the member states are required to lay down the rules on penalties applicable to infringements of this regulation.
Yeah.
And shall take all measures necessary to ensure that they are implemented. Now, whether there's an infringement of a regulation is a matter of EU law, isn't it?
Yes, I think I would accept that, yes.
And if the UK regulations failed to penalise infringements of the regulation, they would not be in conformity with the regulations.
In a very broad sense, my lord, I think with respect that might be right, but the point that I have been submitting is that, and as I say, we'll come to this if we may a little bit later in the morning, but the point that what I've been submitting is, we do deal with it in our written case in some detail. The EU law in this case does not require that there be a criminal penalty.
Yes, what I'm simply pursuing is the point raised by Lord Lloyd Jones as to whether you could lose on the EU point but win on the national point. Yeah.
Well, if what I've been, I'm sorry, if what I've been submitting is correct, in other words, if under national law, if under EU law it is open to member states, firstly to decide on the nature of the penalty, and if it is also open to member states, even if they decide that there must be a criminal penalty, to decide for themselves whether that should be dealt with by way of strict liability.
Well, but that's begging the very issue. Whether, I mean, this turns on Article 23 of the EU regulations, whether on a proper interpretation they permit a member state to fail to penalise conduct which would infringe a regulation.
Well, I'll be able to demonstrate, I hope, by reference to EU law authority, that the way in which Article 23 is reflected in national law does give member states quite a wide margin of appreciation, and that has been decided at EU law level. And my only submission at this stage, because I don't think I can sensibly come to the domestic law position until I've dealt with the EU law position. Well, my only submission at this stage is simply to say, if the primary argument is right on the way in which penalties have to be laid down, then it would follow that I could win on either point 2 or point 3, either on the mens rea point or the attribution point, even if I lose on point 1. That was the limit of what I was saying at this early stage. But of course, I realise I have to make that argument good, and I hope to be able to do so.
Okay.
I was going to go on and simply make a couple more introductory comments and then take you straight to the EU regulation. So firstly, I was going to make this comment that despite the arguments that we advance, which are essentially the arguments that we advance to the divisional court, they have held that a business operator, whether an individual, as it may be, or a company, can be convicted of criminal offences, subjected to an unlimited fine, in the case of an individual given a prison sentence, and on any view be subjected to commercial and social reputational damage, even where no criticism whatsoever is made or can be made of the business operator. And I suppose it was the significance of that decision for businesses generally, not just the appellant, that persuaded the divisional court to certify a point of law of general public importance. And of course, this court subsequently gave permission to appeal. Now, against that introductory background and acknowledging that my time is limited, I'm going, if I may, to go straight to the EU legislation, which is at page E577. It's regulation 1099 of 2009. If anybody's using a hard copy bundle, it's in.
No, we don't have hard copies.
Thank you. Thank you. If we could go first, please, to recital 2 on page E577, and if I can pick that up, perhaps at the 3rd sentence, and just take your lordship through it. Business operators or any person involved in the killing of animals should take the necessary measures to avoid pain and minimize the distress and suffering of animals during the slaughtering or killing process, taking into account the best practices in the field and the methods permitted under this regulation. Therefore, pain, distress, or suffering should be considered as avoidable when business operators or any person involved in the killing of animals breach one of the requirements of this regulation or use permitted practices without reflecting the state of the art, thereby inducing by negligence or intention pain, distress, or suffering to the animal. Now, I don't think it's in dispute that these recitals, and that one in particular, are certainly for the court to consider in deciding on the objectives of the legislation. And there is an authority for that, which I don't think I need take you to.
No, that's right.
So it's the Slovenia case at page E1161. Now, may I make the following comment, please, in relation to recital number 2? Firstly, it may be worth noting the little word or, which appears twice in that passage which I read out, the disjunctive or, which perhaps indicates that the duties on the business operator and the duties on any other person, in particular the individual operative, do not necessarily overlap. That is certainly an important part of our submission. Secondly, the words in the final sentence beginning therefore pain, distress or suffering should be considered as avoidable, especially the word should be considered, are, if I could use this phrase, definitional in character. They do show that the recital is setting out, at least as an element in the objectives of the regulation, what the meaning of avoidable pain is taken to be. Thirdly, it is to be noted, please, that the comma in that final sentence appears after, not after the word regulation in the pre-penultimate line, but after the word art in the penultimate line. So that shows, we submit, that the final phrase beginning with the word thereby applies to both the preceding elements. It applies both to a breach of one of the requirements of the regulation or to the other alternative, the use of permitted practices without reflecting the state of the art. Part of the argument against us is to suggest that the phrase beginning thereby only applies to the latter of those. We submit that the position of the comma makes it clear that the phrase beginning thereby applies to both elements that precede. And overall, if I may summarize what I've been saying, we submit that the last 6 lines of recital 2 are definitional, and that they do include within the definition of avoidable pain the reference to negligence or intention. And that is, we submit, important. It's an inescapable conclusion we respectfully suggest as to the objective of the regulation. Please, going to the regulations themselves.
Just before we do, is it perhaps, I wonder if it might be worth noting that the enabling power for making these regulations is identified as Article 37 of the EC Treaty. So they're made as part of the Common Agricultural Policy. And we can see that a number of recitals identify as a purpose of the regulations to ensure an equal playing field in relation to competition. You see that in recital 3, for example, which talks about differences susceptible to affect competitiveness between business operators, and also recital 5, where we're told that national law on this matter has an impact on competition and accordingly on the operation of the internal market. And again in recital 10, where the competitiveness of the business operators concerned is is mentioned as one of the factors.
Yes, Lord.
Yeah. So they're all pointers towards the importance of these regulations receiving a uniform interpretation across all member states.
I understand that point very clearly, but I suppose it can equally be said that the requirement for uniformity, which is fully understood, doesn't in itself predetermine what the correct interpretation is. Whatever the interpretation is, it will be an interpretation which is binding on member states generally.
Yeah, but the point is, it's going to be an interpretation which can't be affected by domestic legal principles.
In general, that's the case, although, and forgive me for repeating the point, in relation to penalties, what we'll be submitting is that Article 23 goes so far but no further. It doesn't predetermine the exact way in which within the member state penalties have to be defined. But that's a point, as I say, which I'd like to come back to a little later. Would it be convenient now to go to Article 2, please, which is the article which provides for various definitions? And if I can take you quickly to some of those. Firstly, so this is on E584. Firstly, the word killing is defined as meaning intentionally induced process causing the death of an animal. And that, of course, is relevant because we're dealing here with the precise point of the cutting of the artery, which is intended to bring about the death of the animal. Then stunning at little f, which is again an intentionally induced process which causes loss of consciousness and sensibility. Then at letter I, standard operating procedures, which means a set of written instructions aimed at achieving uniformity of the performance of a specific function or standard. So those are, yes, and then finally L, business operator, which means any natural or legal person having under its control or having under its control an undertaking carrying out the killing of animals or any related operations falling within the scope of the regulation. That is of some help, we submit, because it shows that the regulation is acknowledging that whilst the business operator has under its control the undertaking, the business operator, whether an individual or a company with a board of directors as its directing mind, obviously doesn't have control of each and every action or activity on the part of every operative or every employee. Then please Article 3, which is of key importance, and 3.1 to start with. Animals shall be spared any avoidable pain, distress or suffering during their killing and related operations. And we invite attention especially to the words spared any avoidable pain, distress or suffering, words which we submit speak of personal conduct requiring knowledge of the circumstances. Spare any avoidable pain, distress or suffering clearly suggest that that is the language of personal conduct and language seemingly requiring knowledge of the circumstances. And of course, the objective of that provision has to be determined having regard to the language we've already seen in recital 2. Then at 3.2, for the purposes of paragraph 1, business operators shall in particular take the necessary measures to ensure various things, including at D, not show signs of avoidable pain. Now, we would submit in relation to Article 3.2 that the duty on the business operator under 3.2 is a duty to take necessary measures, and therefore that duty does not necessarily coincide, just as a matter of language, with any duties that might lie upon an individual operative. In the case of a business operator, the natural and rational meaning of Article 3.2 must be to take measures which, when complied with, would ensure that, for example, the animal does not show signs of avoidable pain. A natural and rational meaning must be to take measures which, when complied with, would ensure that the animal does not show signs of avoidable pain. That's the only rational way in which to interpret that provision, having regard to the fact that the business operator controls the undertaking, but doesn't control the actions of each individual employee. And we also submit that the wording of Article 3.2, correctly interpreted, helps to clarify, as regards the business operator, the meaning of Article 3.1. Article 3.2 sets out, we submit, how the business operator in particular, as distinct from any individual operative, is to comply with Article 3.1. Then if we could go please to Article 6, which is...
Oh, sorry, before we go to that, what about Article 3.3? Facilities used for killing and related operations shall be designed, constructed, maintained, and operated. Now, so as to ensure compliance with the obligations set out in paragraphs 1 and 2. Now, what I'm wondering is how 2 can be read, inserting the words after measure, which, when complied with, how that could be compatible with the duty in respect of operation in paragraph 3.
My Lord, we would submit that paragraph 3 is addressing facilities in particular. It's taking forward the general requirements in 3.1 and 3.2, not adding anything additional to 3.1 and 3.2, but dealing with facilities and therefore clearly thinking about physical facilities, designed, constructed, maintained, and operated. But it's neutral as to the analysis which we've been seeking to put forward. What we've been trying to put forward in relation to 3.1 and 3.2 is an analysis, an interpretation, if you like, which takes into account the objectives of the regulation, takes into account the role of the business operator, the role of the individual operative, and the relationship between the two, takes into account the fact that the duty on those two individuals or two types of person will not be exactly the same. There may be an overlap, but they're clearly not identical duties. And one of the reasons why we can be certain that they're not identical duties is because the legislation identifies particular duties which lie upon business operators, which are not necessarily those which are the same on individuals. So, with respect, my Lord, I wouldn't concede that 3.3 detracts from the cogency of the general analysis of Article 3 that I've been seeking to put forward. I don't want to repeat myself.
So for example, on your approach, the offences which we're concerned with would not be offences which occurred in the course of the operation of the facilities?
I don't think I need to go as far as to say they didn't occur during the operation of the facilities. I'm certainly not going to submit that. That wouldn't be sensible, I don't think. But the question is,
well, did the occurrence of the offences involve an infringement of paragraph 3?
that hasn't been alleged, my lord. No.
Yeah, well, we haven't been charged with that. I'm wondering on your analysis of the regulations.
Whatever the position may be in relation to individual operatives, and perhaps certainly 3.3 might be relevant in considering whether there was a breach by any individual operative, and you know, no operative has been charged. But the analysis of duty as regards the business operator, I think, would be the same in the case of 3.3 as it is in the case of 3.1 and 3.2, and no reason for it to be otherwise.
So, Mr. Hockman, forgive me, I'm having some difficulty hearing you. When you turn away, your voice drops. I'm really sorry about this, but
not at all.
It's important I should hear what you're saying.
Absolutely. I do have a lapel microphone, and I'm just going to see if that works, and that may make things a little easier. Let me see if. Can you hear me now?
Yes.
That's better. Thank you, Mr. Hockman.
Thank you.
Unfortunately, I can't hear you when I'm using that. I think it's a problem, or I think it's a difficulty with the WebEx system. So I will bring my laptop closer to me and hope that in that way you can hear me. I'm just assuming, my lord, you can hear me as I speak now.
Yes, certainly.
I'll try and avoid turning away to assist. I'm very sorry if that's been a difficulty. So I was going to go, unless I can assist further on Article 3.
No, thank you.
I'll go to Article 6, and lordships will see that this is the article which prescribes that the business operator shall draw up and implement such standard operating procedures to ensure that killing and related operations are carried out in accordance with Article 3.1. So Article 6 clearly provides for the creation of operating procedures to ensure that killing is carried out in accordance with Article 3.1. And again, we submit that the natural and rational meaning must be to create procedures which, when complied with, will ensure the attainment of this objective.
I don't, Mr. Hockman, want to keep interrupting you because I realise you have to develop your submissions, but the subject of the verb shall carry them out is business operators. So if the provision is drafted on the basis that it's the business operators who carry out the killing of animals.
Well, in a broad sense, of course, that is true, because the undertaking is under the control of the business operator. But with respect, that simply cannot, my lord, rationally be read as a reference to some personal activity or conduct on the part of the business operator. With very great respect, it seems to me that one simply has to stand back and look at the language in the regulation as a whole, really everything that we've been looking at, and especially in Article 15, which we're about to come to, and take it what I would refer to, if I may, as a purposive approach to it, and to understand how the language can be given a rational interpretation. It is with very great respect. One of our criticisms of the decision of the Divisional Court, and indeed one of our disagreements with the respondent here, the prosecution, that an over-literal interpretation is being given to some of this language, which leads to the absurdity that a business operator against whom no criticism is made, no criticism of system, no criticism of training, nothing. A business operator who has done all he can in terms of system is nonetheless automatically liable for a breach of the regulations. That we submit cannot be the meaning of these regulations. It wouldn't be rational, it wouldn't be in accordance with the objective defined in recital 2, and it certainly is not in accordance with domestic law either, as we shall see. My Lord, I think I better press on, otherwise I'm not going to be able to assist the court as I would wish to do in the various points that I want to make. So can I go please to Article 15 and take note of the fact, and I'll come back to it in a moment, but just take note first on page E 588 that Article 15 provides that business operators shall ensure that the operational rules for slaughterhouses set out in Annex 3 are complied with. Now, perhaps we could start, or perhaps next we could just look at Annex 3 to complete the picture, and your lordships will find that at page E604, and the relevant provision at paragraph 3.2 E605. And to save time, I won't simply read it out. But I do want to make this submission with regard to Annex 3, paragraph 3.2. This applies to the severing of the carotid arteries, which is obviously relevant here. But please note that it applies in two alternative situations, namely where there has been simple stunning, which is our case, or alternatively, slaughter in accordance with Article 4.4. That's an alternative scenario, which it may be helpful to consider and to which we shall return. Now, I want to make, if I may, a series of points with regard to Article 15 and Annex 3, paragraph 3.2. I think there are 7 points in all, and can I just run quickly through them? Firstly, Article 15 itself shows that the relevant duties are placed upon the business operator, and we submit that that is what might be called a procedural duty. In other words, a duty to include the Annex 3 requirement in its standard operating procedures, which of course is what a business operator would be expected to do. Secondly, the provisions in Annex 3 do not govern the conduct of an individual operative. The duty in relation to them is a duty upon the business operator. Hence, one cannot argue, based on Article 15 and Annex 3, that a breach of Annex 3 by the operative, and it would be a breach by the operative, is one for which the business operator is in some way vicariously responsible. That simply isn't a logical approach which is open to one on the wording or the language of the regulations. Thirdly, therefore, the only rational interpretation of Article 15 is that in requiring the business operator to ensure that Annex 3 rules are complied with, Article 15, like Article 3, is imposing on the business operator a duty to take necessary measures which, when implemented, will bring about the objective, will bring about that which is provided for in Article 15 and Annex 3, paragraph 3.2. Fourthly, this must mean that the measures which the business operator has to take are reasonably within the power of the business operator to take. This is a submission that, in a sense, I've already made in referring to the definition of the business operator. The word used to characterize the duty on the business operator in Article 15 is ensure, and the business operator can only ensure that rules are complied with to the extent that he has reasonable means to control the state of affairs. Fifthly, therefore, if the business operator has adopted or exercised all reasonable means and is thus beyond criticism, then no breach of Article 15, or for that matter Article 3, can have occurred. And note, in particular and by way of example, that the divisional court was clearly in error in holding that a breach of Article 15 and of Annex 3, paragraph 3.2 in particular, would automatically and as a matter of law give rise to a breach of Article 3.1, which was something which they held and which was really the foundation stone of their decision. They were clearly in error in coming to that conclusion, since at the material time when the arteries were supposed to have been severed, the animal would already have been stunned. And stunning means, as we've seen, rendering unconscious. And of course, this would be subject to evidence. But if the evidence so establishes, the animal could well have been unconscious and insensible to pain. So it would be completely inappropriate to hold as a matter of law, as the divisional court did, and as I say, it was a foundation stone of their decision, that by virtue of a breach of Article 15 and of Annex 3, paragraph 3.2, which they attributed to the business operator, that would automatically lead to a breach of Article 3.1. That was an inappropriate thought process on their part. Sixthly, we would say, therefore, that these comments that we ventured to make about Article 15 and Annex 3, paragraph 3.2 represent the only interpretation which is consistent with the objectives of the regulation as described in Recital 2. And seventhly, it's the only interpretation.
Sorry, Mr. Hockman, I can't hear. I can't hear 6 point.
6 point is that it's the only interpretation which is consistent with the objectives of the regulation as described in Recital 2. And seventhly, the only interpretation which applies the regulation in a manner which is rational, proportionate, and effective.
Mr. Hockman, I should perhaps point out that this form of words, operators shall ensure, is very widely used in EU law. For example, in relation to legislation governing health and safety at work, there's a lot of case law on this sort of phraseology. What one finds in other contexts is that if it's intended to be qualified by some phrase such as so far as reasonably practicable, then one tends to find that stated.
Well, my lord, the argument about, if you like, a reasonable practicability exception was one that did feature in the court below, and I can see that one can approach that in two alternative ways. One can certainly imagine a situation in which legislation, whether at European level or at domestic level, includes a phrase of that kind, and then the position is explicit. But we would not concede, on the other hand, that the absence of a phrase of that kind means that it is necessary to interpret the legislation and to interpret its objectives as imposing upon a business operator, liability for individual activities by operatives over which, by definition, he can have no control. And I say by
that's been familiar since the 19th century Factories Act.
Well, my lord,
I mean, it may or may not be the right interpretation of Article 15, but the proposition that it's inherently absurd is a difficult one to accept, because it's familiar both in our own law and in EU law in other contexts.
I'm sure your lordship is referring to the tortious principle of vicarious liability in saying that.
Well, also, I mean, if, for example, an employee is injured because of an unfenced machine, then there will be a statutory offence as well as there being a liability in tort.
Lord, I'm going to come on and deal with the preconditions for strict liability in domestic criminal law. I'm certainly going to deal with that and refer in particular to cases like Lim and Tesco and the Traps. So perhaps I can defer that point until a later stage.
Yeah.
Just picking up and concluding on the point that your lordship raised with me, which is whether the use of the word insure is one which predetermines the issue against me and in favour of the respondent. May I respectfully submit that even though that word may well appear in other legislation, each piece of legislation, even EU legislation, has to be interpreted on its own terms and having regard to its objectives as set out in the recital. And I would respectfully question whether there is any comparable EU legislation which contains a recital which is so explicit as recital 2. Certainly no other EU legislation has been cited against us in this case, and we therefore haven't felt it necessary to go more widely than the points which are taken by our opponents in dealing with the matter against us. But I fully understand that there may be other legislation in which the word insure is used, and as I say, that must surely be construed on its own terms and having regard to its own objectives.
I noticed, Mr. Hockman, that we've lost visual contact with Mr. Perry. I wonder if we could just check that Mr. Perry is able to see and hear what's going on.
Yes.
Thank you very much. Thank you. That's fine.
I'm sorry.
Not at all.
I hadn't realised.
That's fine, Mr. Perry. Thank you.
Right. I was going to make a point on Annex 3, Paragraph 3.2, and the alternative procedure mentioned there of slaughter in accordance with Article 4.4. I don't think time is going to permit me to deal with that. So, if I may, I will, on that point, rely on our written case.
Yes.
I'll also, if I may, try to summarize quite briefly the next part of what I want to say, which is to refer to the other explicit duties on the business operator. Now, it is important to see what those are, and I'll take the lordships through them quite briefly. But we have a long list of explicit duties lying upon a business operator, which are referable to the true role of the business operator as being in control of the undertaking, of having a duty to take necessary measures, which when complied with will achieve an objective. These are duties which shows what the legislator intended as regards the business operator. And they do not, with respect, sit easily against the respondent's interpretation, which presupposed much wider, more general and absolute duties, particularly under Article 3.1 and under Article 15. So just to illustrate these individual duties, firstly, if we can go to page E586, we see there a duty to have competent personnel. Article 7, duty to have competent personnel. And also within Article 7, a duty to have certificates of competence. And the certificates of competence have to cover, among other things, killing methods, the use of knives, and the monitoring of absence of signs of life. And that you will see in Article 21, which is at page E591. Article 21 shows that certificates of competence have to cover, among other things, killing methods, the use of knives, and the monitoring of absence of signs of life. Article 21(1)(b), and we didn't go to it, that cross-refers to a provision in Annex 4, little f, at page E5, at page E606. Now, that may be of importance in this case, because it's one thing for a business operator to have to ensure that he employs competent personnel and that these competent personnel have certificates of competence. Quite another thing to say that a business operator should be responsible for the methods by which knives are used and for the monitoring of the absence of signs of life. He himself doesn't have to have a certificate of competence. He himself may have no skill in the use of knives. And it would be extraordinary if the business operator were to be responsible and capable of being penalized in the case of an individual failure by the business operative in the use of knives, for which he has, by definition, a certificate of competence. Then there is a monitoring requirement, which is in Article 16, page E589. A requirement for an animal welfare officer, Article 17, page E589, who is, this is the way his responsibilities are expressed, is to be in a position to require slaughterhouse personnel to carry out any remedial actions necessary to ensure compliance with the rules. And these responsibilities have to be set out in the standard operating procedures and brought to the attention of the personnel. Over and above all this, there has to be constant attendance, as you know, by an official called the official veterinarian, who is a food standards authority official who is constantly in attendance at the plant, and also the requirement for regular auditing by the food standards authority. So our conclusions on the EU legislation are set out, don't ask you to go to this now, but they're set out for your reference in our written case at paragraphs 78 and 79. And they are, as I've submitted throughout, to draw up and implement standard operating procedures to ensure that operations are only carried out by operatives holding a certificate of competence, and to put in place checks and monitoring procedures in the slaughterhouse to introduce additional oversight in the form of the animal welfare officer. Read purposively and in context, the provisions do create an obligation of due diligence on the part of a business operator. That's in the most succinct form the interpretation for which we contend, an obligation of due diligence on the part of the business operator. That accords with the way the objectives are framed in recital 2. And simply to say, with great respect, that because those words aren't there expressly, because there isn't an express due diligence exemption, that therefore that rules out such an interpretation. That would be to interpret the regulation on a very narrow basis in accordance with the literal words, rather than purposively having regard to the way the business runs, to the relationship between the various individuals concerned, and the objectives as set out in the recital. Then briefly we go on to say that in addition to interpreting the legislation purposely, as I suggested, the court should have regard to some other interpretative principles. So, for example, the principle of proportionality. We deal with this in our written case at paragraphs 80 to 90, starting at page E97. So I won't go through that in great detail. But what we do say, and I'm quoting now from paragraph 89, our written case, is that the judgment of the divisional court creates a burden on a business operator if he's going to avoid liability, to have to watch constantly each of the operatives, so that each operative, bear in mind what I said, 75,000 chickens a day, 20 million a year, to have to watch each operative so as to ensure that they carry out each of the operations for each bird in accordance with the rules. That is what the respondent's interpretation requires. Notwithstanding the fact that the operatives have been officially certificated by the competent authority and have the skills necessary to ensure that they do the job in compliance with the regulation. Otherwise, the effect is that the business operator is always at risk of breaching the requirements of the regulation. So proportionality, we respectfully submit, is a relevant principle here. Equally, the principle of effectiveness, which we deal with in our written case of paragraphs 91 and 93, and I won't take time dealing with that in detail now. Now, let me make one more point on the EU regulations, if I may, which concerns the question of vigilance. The divisional court suggested that absolute or strict liability in this case would engender greater vigilance. But our response to that is that the legislative code already contains a wide range of detailed duties, contravention of which on the part of the business operator could be the subject of prosecution. It would be inconsistent to interpret the legislation as superimposing absolute duties, which by definition would result in a more stringent regime, and one which might lead to a finding of breach, even though the business operator has complied with all the detailed provisions and done all that was reasonably necessary and all that could reasonably be expected of the business operator. In short, in other words, we suggest that it cannot be right to argue that absolute or strict liability would lead to greater vigilance if the business operator has already exercised all necessary vigilance and is therefore not culpable. It cannot be right to argue that absolute or strict liability would lead to greater vigilance if the business operator has already exercised all necessary vigilance and is therefore not culpable. Now that, we suggest, logical proposition is given eloquent expression in a Canadian case, and I'm going to take your lordship to relatively few of the authorities, but let me, if I may, take you to this one by way of conclusion on the EU side of things. It's at E1259. It is a case in which a local authority was convicted of a pollution offence, which resulted from the operations of an independent contractor. And I'd like to go, please, to a passage in the judgment of Justice Dixon at page E1271. In which he summarizes the concerns that we've been expressing.
Mr. Hockman, I'm sorry, I'm going to have to interrupt you because we have apparently lost contact with Mr. Perry. It may take a few minutes to sort this out, I'm afraid. So I think we should adjourn for the moment, and I'll let, our engineer will let everybody know when the problem has been resolved.
I understand. Thank you.
Mr. Perry, I'm afraid I'm not sure how long we were without you.
I saw everything because I've also I'm also looking at another screen. I haven't missed anything. It's just
right.
that you lost me, and I'm very sorry.
No, not at all. No, these things happen.
Lord Reid, I have asked Victoria, who's with Mr. Perry, to set up another network connection, just so that there's minimal interruption for the remainder of this session.
Right.
Victoria will inform David once that's been set up and he's connected.
Right. Can we continue in the meantime? Or should we wait until the new connection's established?
And we need to wait until new connection is established.
Fine.
I would be happy to carry on because my screen is currently working rather than lose any time.
Yes, if you can watch us in any event on the.
I can watch and follow in any event.
Fine.
So we don't need to lose any time at all.
Right. Okay, well, Theo, I think we're ready to resume.
Yes, 10 seconds from now.
Well, I'm sorry for that technical interruption, Mr. Hockman. We're now ready to resume.
Thank you very much, my lord. And could I ask the court, please, to go to E1271? I just want to cite, by way of conclusion to my discussion of the EU regulation, this passage by Justice Dixon about the arguments against absolute liability halfway down the page. The most telling, he says, is that it violates fundamental principles of penal liability. It also rests upon assumptions which have not been and cannot be empirically established. There is no evidence that a higher standard of care results from absolute liability. If a person is already taking every reasonable precautionary measure, is he likely to take additional measures, knowing that however much care he takes, it will not serve as a defense in the event of breach. If he has exercised care and skill, will conviction have a deterrent effect upon him or others? Will the injustice of conviction lead to cynicism and disrespect for the law on his part and on the part of others? These are among the questions asked. The argument that no stigma attaches does not withstand analysis, for the accused will have suffered loss of time, legal costs, exposure to the processes of the criminal law at trial, and however one may downplay it, the opprobrium of conviction, it is not sufficient to say that the public interest is engaged and therefore liability may be imposed without fault. In serious crimes, the public interest is involved and mens rea must be proven. The administrative argument has little force. In sentencing, due diligence is admissible, and therefore the evidence might just as well be heard when considering guilt. My lords, those are my submissions on EU legislation. This might be a convenient moment to have another short break if that's convenient. Alternatively, if your lords prefer, I'll carry on for a while. I'm rather in your hands.
Yes. I think if any of my colleagues feel the need for an adjournment, they can let me know by email. But I think in the meantime, just carry on, Mr. Hockman.
I will. Thank you very much indeed. Thank you. So, dealing with the national legislation, and let me come now to the submissions that I want to make and that I foreshadowed earlier on a point that was troubling my Lord Reid and my Lord Lloyd Jones, as to the discretion that member states have in relation to penalisation. Now, Article 3, which your lordships have obviously seen, is at page E592. We would point out that whilst requiring member states in general terms to lay down rules on penalties applicable to infringement, and whilst providing that the penalties must, in general terms, be effective, proportionate, and dissuasive, Article 23 otherwise leaves member states a wide margin of appreciation as to the nature of those penalties and as to the circumstances in which those penalties are applied. Thus, the penalties can be criminal or civil or administrative. The regulation does not prescribe the precise circumstances in which any particular form of penalty should be imposed. And I might just comment that this is that remains true, even if other provisions in the regulation are more specific and are clearly designed in their specificity to achieve harmonization between member states. The fact that in general terms the objective of the regulation is to achieve harmony doesn't mean that where you have a particular element which is expressed in more general terms and which on its face allows member states a discretion, doesn't mean that that is inconsistent with the objectives and the proper interpretation of the regulation as a whole. Now, I'd like to refer the court, please, to the Van der Ven case, which is at E970. That's the opinion of the Advocate General, and E976, which is the judgment of the court. And I'm going to show you in particular the passage from the judgment of the court in a moment. The court was concerned there with a regulation on the harmonization of road traffic legislation. In fact, I think perhaps we might look at the case straight away. Just find it. So, dealing first with the opinion of the Advocate General at page E970. And just going to paragraph 8 of the opinion of the Advocate General.
I wonder if it isn't worth looking at paragraph 4 just to see what the relevant provision, legislative provision, was.
Yes.
I mean, one can see from paragraph 2 of Article 15 that the obligation on the, well, under 1, the obligation on the undertaking related to how it organized drivers' work, so as to enable them to comply with the regulation. Then under 2, they were to make checks, and if breaches were found to have occurred, they had to take appropriate steps to prevent repetition.
Yes. However, my understanding is that the provision as to penalties was in comparable terms to the provision in Article 23.
Yes, yes, well, yes. I suppose the question is whether Article 15 of this regulation bears any resemblance to the provisions we're concerned with in the present case.
Well, my Lord, with respect, the issue that we're dealing with now is the scope given to member states in relation to penalties. And what we will see, as I foreshadowed earlier, is that in this decision, both in the view of the Advocate General and then subsequently in the view of the court, it's open to member states to decide for themselves whether to impose penalties on the undertaking, and if so, whether there should be strict liability. Now,
they construed the regulation as imposing merely a best endeavours obligation. So so there was no question of a regulation imposing strict liability, but the member state, if it had a power to impose a higher standard domestically, then obviously it could do that.
Well, nonetheless, my Lord, the issue that was discussed, I mean, if we look at the issue in the opinion of the Advocate General first, under the heading strict liability of legal persons, so this is on 973. Towards the end of paragraph 7. In this connection, the Court of Reference asked whether the regulation has the effect of introducing into member states' national law the principle of criminal liability of legal persons. In other words, whether it requires member states always to impose on the undertaking, even where it is a legal person, the penalties adopted in implementation of Article 17. And the Advocate General goes on to say, citing an earlier case, member states have a discretion which, it is true, is subject to 2 conditions under Article 5 of the EEC Treaty. First, they must ensure that the penalties are effective, proportionate and dissuasive. So that's the exact equivalent, or at least very similar to Article 23. And secondly, member states must penalise infringement in the same manner as infringements of national law of similar nature and importance. Community law, it's a proposition in general, proposition relating to community law in general. Community law leaves the member states free to choose the means for achieving these aims. They may choose between criminal, administrative, or purely civil penalties. They may decide to impose these penalties always on the undertaking, or in certain cases on the representatives or members of staff of the undertaking, who, with regard to the specific infringement, bear the actual responsibility for the operations of the undertaking concerned. As long as national rules on penalties comply with the conditions mentioned, neither Article 17 of the regulation nor Article 5 of the EEC Treaty requires the member states to make the legal persons to whom the infringement of the obligation is laid down by Article 15 of the regulation may be ascribed themselves criminally liable. And then if we go to the judgment, which starts at page E976, we see firstly at the top of 981, E981, very similar phraseology. The answer to the second question raised should therefore be that neither Article 5 of the EEC Treaty nor Article 17 of the regulation requires a member state to introduce into its national law the principle of the criminal liability of legal persons. Infringements of Article 15 may be restrained by the application of provisions in conformity with the basic principles of national criminal law, provided that the resulting penalties are effective, proportionate, and dissuasive. So, your lordships would have to go so far as to hold that national law, on its proper interpretation, would not achieve an outcome which was effective, proportionate, and dissuasive in order to side with the respondent in this case. And in so doing, your lordship would, with great respect, have to set to one side the logic and the, I would respectfully submit, common sense of Justice Dixon in the Canadian case, and reach the conclusion that to be effective, proportionate, and dissuasive, you have to penalise people, even though they've done nothing to be penalised for.
But the starting point here is to identify in that sentence, the starting point is infringements of Article 15. So you have to work out whether, in that case, Article 15 imposed strict liability or not. On proper interpretation, it didn't, and therefore there was no requirement on national law to penalise conduct which wasn't attributable to the fault of the operator. But if, on the other hand, Article 15 had imposed strict liability, then national law would have to, in conformity with its principles, penalise that infringement.
Well, I think, my lord, that the way I would seek to put it is that that is not a requirement of Article 23 of this regulation. The Article 23 limits itself to requiring penalties which are dissuasive and so on.
Yeah, but that, when we say so, has got nothing to do with it. The starting point in Article 23 is that infringements of a regulation must be penalised. So you have to work out what constitutes an infringement of the regulation. That's the whole point.
Lord, before I deal with that a little more fully, let me just refer to paragraph 17 of the judgment, just to conclude the reference, where we see that there is an express recognition that the introduction of strict criminal liability on the part of an employer is not compulsory. Member states have a discretion as to the penalty to be imposed in the event of breach of the regulation.
Yes, if you go back to paragraph 15, you'll see that it may be seen from the actual terms of Article 15 that the obligation thus created is an obligation to use best endeavours. Last sentence, it follows that the finding that a breach of a regulation has been committed by a driver employed by the undertaking is not in itself enough to establish that the undertaking has failed to comply with its own obligations. So the implication of that is there's no infringement by the undertaking, and therefore no obligation on the member state to criminalise the undertaking because of what had occurred.
But my lord, in this case, with great respect, the position is analogous, because on any view, nobody is suggesting that there was a breach by the business operator personally. It could have been an individual. In this case, it was a company with a board of directors who would be its directing line. Nobody is suggesting that the breach in question could be attributed to them personally. The way in which under EU law, leave aside domestic law completely, the way in which under EU law they could be found to be in breach would only be by virtue of having a responsibility for what was done by others, for what was done or omitted to be done by individual officers.
Yes, and if you're right about the interpretation of a regulation, then everything else follows.
Well, my lord,
what I'm taking issue with is whether, if you were wrong about the interpretation of a regulation, nonetheless domestic law could enable infringements of a regulation not to be penalised because of an absence of fault on the part of the operator.
But Lord, the point that I was making, I'm sorry if I haven't yet made myself clear, is that, of course, our approach to the interpretation of the EU regulation is that there is no breach by the operator at all. And the reason for that is because you have to give it a purposive interpretation. I won't repeat all those arguments. But the point I was making to your lordship in the context of Van de Ven is that even if we're wrong about that, and even if, as the respondent suggests, there was a breach of the EU regulation, it is not alleged that it was a breach as a result of any conduct by the business operator person. It's not alleged that it was anything other than the sort of breach that occurred in this case, which was a breach that flowed from activity by an employee. And that is clear, respectfully, from paragraph 15. So there is an exact analogy in our respectful submission between the approach of the respondent here and the Van de Ven case. The liability on the part of the appellant is in, if you like, in national law terms, vicarious or strict, whichever phrase one cares to use. It's not an allegation of misconduct, culpable conduct on the part of the business operator. And the question is, what is mandated in terms of national law in those circumstances? And our submission is that Van de Ven shows that in such a situation where the business operator is not personally culpable, there remains a discretion on the part of the member state. It doesn't have to impose criminal penalties, but if it does, then it certainly doesn't have to impose strict liability. In other words, automatic criminal liability. And for that, we respectfully submit that paragraph 17 of the judgment of the court, page 982, is good authority.
Yes, Lord Burrows has a question.
Yes.
Do I understand your submission to go as far as this? Are you saying it is open to the member state in this situation not to impose criminal liability at all in relation to the implementation of this particular EU regulation? Might it, on your submission, have relied entirely on the civil law in some way?
Yes, my lord, that would be our submission. Of course, if that goes too far, that wouldn't be determinative, because even if I'm wrong about that, and even if the imposition of criminal penalty were required, that would not predetermine the form of penalty or the preconditions, circumstances in which penalty should be imposed. But it is our understanding that Article 23 does not mandate the imposition of a criminal penalty in all circumstances. And if it did, my lord, then why, if I may ask rhetorically, why would it not say so? If the purpose of Article 23 were to impose an obligation on each member state to make it a criminal offence to breach the regulation, and if the purpose was to make it an obligation on every business operator to impose an obligation on the member state to impose a criminal penalty on a business operator in the case of any breach, then it could very easily say that.
I mean, it's true to say, isn't it, that the charges brought in this case could not have been brought directly in relation to an infringement of the EU regulation. You could not have charged somebody directly under the EU regulation, because it isn't creating a criminal offence in this jurisdiction. So you have to proceed by charging a criminal offence in this jurisdiction, which is the breach of the domestic regulations. That's correct, isn't it?
Yes. But with respect, that's precisely the way we submit that the regulatory system operates. The EU regulations lay down the regulatory scheme. Clearly, the precise meaning or the precise way in which that scheme should be interpreted is a matter of hot debate in this case. But the fundamental submission we make is that the EU regulations could have been prescriptive as to the form of criminal liability to be imposed, particularly having regard to the fact, I mean, the EU regulations were enacted, were adopted in 2009, several years after the Van der Ven case, for example. So it would have been possible for the legislators within the EU to say to themselves, well, under EU law, there is no obligation on member states to impose strict liability on a business operator, but we want to make sure that that happens in every case here, so we will make that clear. But that's not something that they have chosen to do. And it's perfectly understandable as a matter of policy that they might choose not to impose an absolute obligation on member states to penalise criminally business operators when they are not in any way culpable. And certainly not to make them liable to criminal conviction when they're not in any way culpable.
I should say that what I've been putting to you there, I don't think says anything about the actual ultimate interpretation of the domestic crime. I'm just trying to get clear in my own mind whether we're essentially talking about the interpretation of a domestic crime, or are we talking about a domestic crime that's importing something from the EU, or are we in a different ballgame altogether and primarily interpreting an EU regulation?
Well, thank you, my lord. I think I can derive some help from that, because as your lordship points out, since the EU regulation doesn't itself define criminal offences, ultimately those offences have to be defined in domestic law. The way in which domestic law approaches such offences, the definition of the offence under domestic law must be a matter for domestic law. So the point of debate at the moment, and I think I'd better move on fairly quickly, otherwise I'm going to run out of time. But the point of debate at the moment is really as to whether EU law constrains member states, constrains the scope of the criminal law within a member state. And our submission is that it would take much clearer language in the regulation for that to be the case.
But we may be in danger of reinventing the wheel here. There's about 40 or 50 years experience of criminal offences of this kind. For example, fisheries offences under the common fisheries policy. And it's long been established that you can't use domestic criminal principles. For example, there's a case of Lord Hope of Craighead's called Westwater and Thompson back in about 1980 or so, where the argument was that the offence had to be narrowly construed in accordance with the domestic principle that penal provisions are given a narrow construction. And that was rejected because because the offence had to be construed so as to give effect to the EU regulation, and therefore the relevant provisions of the domestic statute had to be construed applying EU principles and EU case law in accordance with the European Communities Act. And that's very well established law. I think it goes back to Hen and Derby in the House of Lords. It's Lord Diplock. That's a long time ago.
Yes, Lord, I think I'd seek to draw a distinction between a provision in domestic law which is inconsistent with the regulatory scheme on the one hand, and a provision in domestic law which is actually within the scope of the regulation itself.
Yeah.
On the other. And that's the distinction that I'd seek to draw. And without repeating myself, I'd simply emphasize that our submission, based as it is on what we submit, is the wide margin of appreciation given by Article 23, is that it's open to us to make the submission, which I'd like to go on and make now, if I may, on domestic law that we do seek to make. So if I may, I will move on to those arguments, unless I can assist further on the point that we've been dealing with in the last quarter of an hour or so.
I'm just wondering whether, Lord Burrows has raised a very interesting question, whether when the regulation in Article 23 requires member states to impose penalties, that gives it a discretion to impose civil penalties rather than criminal ones.
Yes,
I don't imagine that's a question that you've prepared any answer to.
I think. Can I check that when we adjourn, please? I think the answer to that does appear. I think possibly in the Van der Ven case, or if not somewhere else in the material that we have. So I will, if I may, try to assist your lordship on that. But I'm pretty confident that there is authority to the effect that the penalties do not have to be criminal penalties.
Yes. Yes, provided they are effective, proportionate, and dissuasive.
Yes. Yes.
And also respect the principle of equivalence. So they're similar in nature, the penalties that would be imposed in an analogous situation in domestic law.
Yes. I think it might be in the Advocate General's opinion.
Yes, I've just found it. It's in paragraph 8 on MS 973.
That's right. Exactly. Halfway down the right-hand column in paragraph 8. Thank you, my lord. That's it. That's what I had in mind. So if I might move to the two dimensions of English criminal law, which we respectfully submit that the court has to consider. The court...
I'm sorry, just to interrupt.
Yes.
It could hardly be a civil penalty. I mean, the chicken doesn't have a right of action. You could have an administrative penalty, I suppose, closing down the plant, for example.
I suppose it depends what one means by a civil penalty, but the concept of what are called civil penalties is now quite well known in the environmental sphere. I think they are called civil penalties. So the Environment Agency has power to, as an alternative to prosecution, to impose what are described as civil penalties. So that is in the case of a business.
Yeah, frequently the police for speeding nowadays.
I think so.
Impose civil penalties.
Yeah, yes. So it is in its impact the same as a fine. It's a monetary penalty. It doesn't mean that there has to be a civil dispute between two parties.
No.
Lordship will guide me as to whether I ought to move on or.
Oh, I think so. Time is moving on, Mr.
Yes, thank you very much. So, what I was saying in relation to domestic criminal law is that there are two aspects to this. Firstly, we submit that the prosecution have to prove that the business operator acted culpably in the sense that those constituting the directing mind of the company intentionally or at least negligently contravene the EU regulation. Alternatively, and even if that's wrong, the prosecution have to prove that the acts or omissions of the operatives responsible for the contravention can be attributed to the defendant company. But these are separate, if you like, principles or elements in English criminal law. One relates to state of mind or the intention or carefulness of the defendant on the one hand, and the other relates to the actual activity, the actus reus, on the part of the defendant, and whether that actus reus can be if whether the action of the individual operative or employee can be attributed to the company. Now, the national regulations themselves are at E759, Regulation 30 of the weight off regulations. I'm sure your lordships have looked at those. And what they show is that the offence can only be committed either by causing or permitting someone to contravene the EU regulation or by contravening it personally. And we would submit, firstly, that the word contravene itself connotes a positive act with knowledge of relevant circumstances. And we submit that one reason why that is the appropriate interpretation is precisely because the legislative scheme does not contain a due diligence defence. If the legislation intended to impose on the contravener liability without proof of a positive act with knowledge of relevant circumstances, then a due diligence defence would inevitably have been included. Now, for this purpose, we need to look at a handful of cases, please, and I will do this as efficiently as I can. So, can I take you first to the very well-known case of Sweeten Parsley, which is at E1043. I'm sorry, I think that might be an incorrect reference. Could you bear with me just one moment? Sweeten Parsley is at E1403. E1403. And here we find a restatement of the classic principle, E1403. Looking at the last couple of paragraphs in the headnote, mens rea is an essential ingredient of every offence, unless some reason can be found for holding that it's not necessary, and the court ought not to hold that an offence is an absolute offence, unless it appears that that must have been the intention. Lord Diplock in particular says it's a general principle of construction of any enactment that creates a criminal offence, even where the words used to describe that prohibited conduct would not in any other context connote the necessity for any particular mental element. They are nevertheless to be read as subject to the implication that a necessary element in the offence is the absence of belief held honestly on reasonable grounds in the existence of fact, if true, would make the act innocent. And I don't think we need to go at this stage to any particular part of the speeches of the House of Lords in Sweet. Then there is the case of B, and if we could go to that at E820. A case in which the allegation was of an act of indecency, and the issue was whether the defendant honestly believed that the girl was over the age of 14. Again, from the headnote, mens rea an essential element of every criminal offence, unless Parliament expressly or by necessary implication provided to the contrary, and that on a true construction of the legislation, Parliament has not so provided. Therefore, consequential burden of proof on the prosecution, and specific passages in the speech of Lord Nichols, which I need to go to at E852 and E856. Now, of course, we acknowledge that there are cases which have been described as involving issues of social concern, so-called, a description which we suggest could apply to almost any case in which statutory restrictions apply. And such cases are sometimes said to be at least potentially capable of attracting strict liability. But as Lord Steyn emphasised in this case of B, at page 864, and if I could take the lordships to E864, Lord Steyn on social concern at letter B on E864. He cited the case of Lim, which I shall go through in a moment. Not enough, in their lordship's opinion, merely to label the statute as one dealing with a grave social evil, and from that to infer that strict liability was intended. Their lordships no doubt had in mind, says Lord Steyn, that the prevalence of even a grave social evil does not necessarily throw light on the question of what technique was adopted to combat the evil, whether the creation of an offence of strict liability or an offence of which mens rea is an ingredient. That's an important general proposition from a very well respected exponent of the criminal law, among others. So we submit that in many cases, even of social concern or alleging a social evil, proof of fault or want of competence or care is still required. And let me refer now to a group of cases, 3 cases, Lim, Tesco and Gammon, in which that point was discussed, the need for some degree of want of care. So if we go first to Lim, please, which is at E1125. We can go straight to the passage in the opinion of Lord Evershed at page 1139. Evershed at page 1139. About halfway down the page. It's not enough, he says, in their lordship's opinion, merely to label the statute as one dealing with a grave social evil, and from that to infer that strict liability was intended. It's pertinent also to inquire whether putting the defendant under strict liability will assist in the enforcement of the regulation. That means that there must be something he can do, directly or indirectly, by supervision or inspection, by improvement of his business methods, or by exhorting those whom he may be expected to influence or control, which will promote the observance of the regulations. Unless this is so, there is no reason in penalising him, and it cannot be inferred that the legislature imposed strict liability merely in order to fine a luckless victim, referring to 2 earlier cases. Their lordships prefer this to the alternative view that strict liability follows simply from the nature of the subject matter, and that persons whose conduct is beyond any sort of criticism can be dealt with by the imposition of a nominal penalty. Now that's perhaps an important passage. Their lordships prefer the alternative view, not the view that persons whose conduct is beyond any sort of criticism can be dealt with by the imposition of a nominal penalty. The latter view can perhaps be supported to some extent by other dicta, but though a nominal penalty may be appropriate in an individual case where exceptional leniency is called for, their lordships cannot with respect suppose that it is envisaged by the legislature as a way of dealing with offenders generally. where it can be shown that the imposition of strict liability would result in the prosecution and conviction of a class of persons whose conduct could not in any way affect the observance of the law, their lordships consider that even where the statute is dealing with a grave social evil, strict liability is not likely to be intended. Now, it's worth noting, therefore, we respectfully suggest that the board was clearly of the view that proof of a relevant criticism is a component in the offence, and hence they rejected the view that persons whose conduct is beyond any sort of criticism can be dealt with by the imposition of a nominal penalty. And we suggest that there is a marked contrast between the approach of the board as set out there by Lord Eversham and the approach of the respondent in the present case, who suggests that the criticism is not an ingredient in the offence, but merely the consequence of it, merely an element which may frequently but not always occur. The board is making it quite clear that persons whose conduct is beyond criticism should not have to face the opprobrium of being prosecuted and subjected perhaps to a nominal penalty. The respondent's approach here, subtle though it may be, is inconsistent with this line of cases which I'm taking you through now, starting with Lynn, and the next one, which makes the matter even more clear because it's a case involving the relationship between employers and employees, is Tesco. That is at E1438. Trade descriptions case. And if we can go to the speech of Lord Diplock at 1479, E1479. Between letters D and E, where he speaks of the rational and moral justification for creating in the field of consumer protection, as also in the field of public health and safety, offences of strict liability for which an employer or principal in the course of his business the offences are committed is criminally liable, notwithstanding that they're due to acts or omissions of his servants or agents, which were done without his knowledge or consent, or even were contrary to his orders. But this rational and moral justification does not extend to penalising an employer or principal who has done everything he can reasonably be expected to do by supervision or inspection, by improvement of his business methods, or by exhorting those whom he may be expected to control or influence to prevent the commission of the offence. What the employer or principal can reasonably be expected to do will depend, etc., etc. So, once again, you have the notion of criticism, you have the notion of whether the employer has, to quote Lord Diplock's express language between letters E and F, whether he's done everything that he can reasonably be expected to do by supervision or inspection and so on. That is this case. There is no allegation of systemic failure of any kind. That deals specifically with the position of the employer. Just in this sequence, dealing finally with the case of Gammon, which is at E984. This was a case in which a building contractor had deviated from some plans, and a case in which it was accepted on all sides that the contractor would not be liable unless he knew about the deviation. The only issue is whether he needed to be proved to know about the materiality of the deviation. And the key passage perhaps is at page E1001, E1001. Where in the opinion of Lord Scarman on behalf of the board, one sees this at letter C. The wording of subparagraph B clearly requires knowledge of the approved plan and of the fact of deviation. But in their lordships' view, it would be of little use in promoting public safety if it also required proof of knowledge of the materiality of the deviation. As it was put on behalf of the Attorney General, if the offence requires knowledge of the materiality of the deviation to be proved, the defendant is virtually judged in his own cause. The object of the provision is to assist in preventing material deviations from occurring. If a building owner, an authorised or a registered person, is unaware of the materiality of the deviation which he authorises, and knowledge of the deviation is necessary, he plainly ought to be. And then quoting the Court of Appeal at the end of the paragraph, it behoves the incompetent to stay away and the competent to conduct themselves with proper care. So even in gammon, you have this notion of a duty of care being an essential, a breach of a duty of care being an essential component. And I suppose there might be an analogy between gammon and the present case. One might say that the appellant might more plausibly be said to be guilty if he knew that the carotid arteries were not going to be severed, if he knew that there was some practice to that effect, even if he tried to claim that he didn't realise the materiality of that particular requirement. That would be the analogy of the present case. But there is no analogy which says that the business operator is liable in our situation if we have absolutely no idea that the offence was occurring. What we are asking the court to hold, and of course the case is still at a preliminary stage, we are asking the court to hold that the culpability in some form is an essential component in the definition of the offence. Now, I'm going to conclude what I have to say on the mens rea issue, the second issue, because I want to leave myself with a little bit of time to deal with attribution. I'm going to conclude what I say on the mens rea aspect by pointing out that there are a number of cases in the material before us. Going back to 1895, the case of Sherris and Erupson, and coming all the way down to a case called Matudi in the year 2003. I think about 9 cases in all of them based on specific legislation, all of them interpreting specific legislation. Some, it is true, holding that, if you like, the business operator, the business itself is liable because the offence involves the sale of goods or the using of a vehicle, and it's said that the business, by definition, is the seller or the user in those particular cases. Even then, there are some cases. There's a case, as I said, called Sherris and Rutson. There's another case called Reynolds, in which that conclusion was not drawn, and in which it was held that the defendant was not liable. There is a group of cases easily distinguishable from the present, in which the fact that the activity is such that only the owner of the business can be responsible, leads to a particular result. In other cases, the court is content to hold the defendant liable because there is an express due diligence or statutory defence, and that makes all the difference. And in one or two cases, and the Matuidi case in the Court of Appeal is one of them, even though a phrase such as strict liability is used, the court nevertheless concludes that there was a want of care and that there were measures which the accused could reasonably have taken. So in those various respects, one can account for the decision in these individual cases that they are distinguishable from the present case, and they do not constitute an obstacle to the conclusion which we invite this court to reach in the legislative context here. Now I'll move on, if I may, to my third and final issue, which is the issue of attribution. And as you've seen from our written case, we do submit as a separate ground of challenge that it is necessary for the prosecution to prove that there is a proper basis in the context of the legislation for attributing to the business operator the acts of the individual operative. And there are really two main limbs to this argument. Firstly, and considering the national domestic legislation, considering the EU legislation, we would remind the court that running through that legislation, there is a distinction, a clear distinction, between the imposition of duties on the business operator on the one hand, and the imposition of duties on the operatives on the other. And we suggest that where the legislation itself differentiates between the duties imposed on those two different groups of people, that is a strong indicator that it is contrary to the legislative intent to presume or to overlay the concept of attribution onto these provisions. So the primary legislative scheme, EU legislation, doesn't really give scope or have room for some sort of automatic attribution, which under domestic law anyway, is a necessary requirement for the proof of the offence. Secondly, if one looks at the domestic legislation, and if one looks at the way in which Regulation 31G is formulated, two forms of offence would appear to be created. The first is where the defendant itself contravenes a provision in the European Regulation 1099. Second form of offence is where another person contravenes the regulation and the defendant causes or permits that person to contravene the provision. Again, we suggest that the way in which the domestic legislation is structured shows that it is not intended that someone should be criminally liable for the acts or omissions of another person unless the defendant causes or permits the contravention. The national legislator has expressly provided for the business operator to be criminally liable for the acts or omissions of the person involved in the killing if the business operator causes or permits that person to contravene the EU regulation. And again, that rules out or leaves no scope for a conclusion that there is some independent possibility of attribution which enables one to say that the business operator has contravened the legislation. The enactment of the statutory form of secondary liability, using the words causal to me, points away from a rule of attribution whereby a business operator is criminally liable, necessarily and without more, for the acts or omissions of its operator. If the business operator were to be liable for a contravention on that basis, there would be no need for the provision of the alternative scenario of causal. And it's worth noting that the divisional court really never grappled with the issue of attribution. Its ruling, and this is in paragraph 94 of the judgment at page E189, its ruling was E189, the intention of the 2015 regulations, meaning the weight-off regulations, the domestic regulations, into which the EU regulations directly feed, is that the business operator should be liable if the necessary facts are established, and the divisional court said, without the need to prove mens rea. There is no separate and additional requirement to prove culpability. And that passage in the judgment seems to show that the court erroneously proceeded on the basis that once it had decided that the offence did not require proof of mens rea, then the acts of a servant could be attributed to the principal. It failed to analyse the statutory scheme from the perspective of whether attribution was intended. My lords, those are our submissions under each of the three headings, and I've finished 5 minutes before my allotted time because I was obviously timing this to the minute, and I'd assumed that there would be a 5-minute break. So unless I can assist further on any of the 3 points, with respect, I do still adhere to the proposition that any one of those 3 points would suffice from my point of view, and I'll bring matters to conclusion and see whether Mr. Perry can persuade your lordships, as I suggest he has to do, on all 3.
Yes. Well, I don't think we have any questions for you at the moment. We've asked you plenty, at least I've asked you plenty earlier this morning, and thank you for dealing with them with patience and good humour. Thank you very much, Mr. Hockman. We can turn now to Mr. Perry.
Thank you very much, my lord. May it please the court, my lord, may I begin by making some introductory submissions which I hope will encapsulate the basis upon which we advance our case. First of all, the respondent's essential submission is that the key point underlying this appeal is the fact that the EU regulations are to be applied consistently throughout the European Union. That means that their meaning and scope must be identical in all member states. They were intended to introduce a comprehensive and harmonized scheme not subject to variation or varying standards of implementation and enforcement. The second point that we make in relation to that, in answer to one of the questions that was put to my learned friend at an early point of his submissions this morning, is that it is not open to the United Kingdom to depart from the EU regulation, because that would introduce the very vice of disharmony, not only in relation to animal welfare, but also in relation to the internal market within the European Union, as the recitals to the regulation make clear is a vital component of the legislative scheme. The domestic regulations, therefore, add little or nothing to the EU regulations in terms of liability. They are simply the mechanism by which a contravention of the relevant part of the legislative instrument of the European Union becomes an offence in the United Kingdom's domestic legal order. It follows that there is simply no scope for reading into the regulations peculiarly English concepts of criminal liability or culpability, particularly where those concepts of criminal liability or culpability have no equivalent counterpart in the European Union. For example, English law concepts such as the rules of attribution as the basis for determining corporate liability, those concepts, which I would submit are peculiarly parochial and English concepts, would have the effect of undermining competition between member states and distorting the internal market, because it would mean that the threshold for liability within the United Kingdom would be set at an unrealistically high level. And secondly, it would make the regulations well nigh impossible to enforce, which would not be persuasive, would not be proportionate, effective, or dissuasive, to use the terms of Article 23. If mens rea is required, adopting the appellant's case, the prosecution would have to prove, on the basis of the principles of attribution, that a significant corporate figure had knowledge of any relevant failing or deficiency in any particular case, and that would in turn require an analysis of the corporate entity's constitutional documents and management. It would work to the advantage of the bigger corporations and to the disadvantage of smaller enterprises, where the rules of attribution work more easily with a small senior management. We also note that my learned friend's reliance on some presumption of negligence is not actually part of the common law's presumption of mens rea. All the authorities from Sweet and Parsley onwards through B and the DPP make clear that there is no presumption of negligence as a basis of liability. Negligence is not traditionally, as a matter of English criminal law, taken to be a state of mind. It is ordinarily regarded as an actus reus requirement, because where negligence is a basis for liability, it usually connotes a failure to conform to an objective standard. We rely on the general tenor of the authorities to the effect that strict liability is particularly apt where the offences in question are directed towards controlling the activities of corporations, the point that was made by my Lord Reid, going back to at least the 1840s in England and Wales, And there are two reasons why strict liability is particularly apt towards controlling the activities of corporations. First, corporate convictions do not normally involve the same level of stigma as those attaching to the conviction of individuals. And second, proof of mens rea presents special difficulties in this type of context, as there may be no person who can in fact be identified as the company for the purposes of liability. This point is made by the commentator who wrote the commentary to the decision of the Divisional Court in this case, which perhaps I could just give your lordships the reference without turning it up, but it's in the electronic bundle at page 1491. The commentary is by Carl Laird, and the commentator makes the point that if the offence is construed so as to require mens rea, Parliament's aim in enacting the offence would have been fatally undermined, given the difficulty in pinpointing the individual upon whom the requisite state of mind must be attributed. So our submissions, therefore, really boil down to these propositions. The offences are ones of strict liability. There is no mens rea or fault element such as knowingly, intentionally, or recklessly, nor does negligence assist the appellants. It is unnecessary to prove that anyone acting as the directing mind of will of the appellant company carried out or was responsible for any relevant act or omission. And the critical point is that to accept the appellant's argument would undermine the implementation of the EU regulations and provide domestic operators in England and Wales with an advantage which they should not be afforded. For these reasons, we will be submitting that the Divisional Court was right to conclude that the EU regulations are to be seen as a comprehensive code or rule book which must be complied with at all material times. See the judgment of Mr. Justice J at page 188 of the bundle at paragraph 88 of the Divisional Court's judgment in what we would submit was an extremely careful judgment, although the debate before the lower court did not focus on the operation of the internal market, which we submit is an important dimension to the arguments in this case. We also submit that, quite apart from the need to apply the regulations consistently throughout the European Union, the offences are just the type of quasi-criminal offences which the courts have long recognised as being appropriate to deal with by way of strict liability. That is, even assuming that this is a domestic law point, which we submit it is not. But even if one applies domestic law, the position is that these provisions are intended to regulate a specialist activity, and the fact that the industry is overseen by a specialist agency, the Food Standards Agency, and not the police, is itself indicative of their quasi-criminal nature. The regulations operate in the realm of animal protection and welfare, and the protection of those interests requires high standards of care and attention. And contrary to the submissions made by the appellant, they are designed to promote vigilance on the part of business operators to prevent the commission of the prohibited acts. With that,
I'm afraid we have lost you, Mr. Perry.
I'm very sorry, my lord.
No, not at all.
Technical difficulty. I'm very sorry. But Lord, with those introductory comments, may I just very quickly turn to the EU regulations to make the points that we wish to make in relation to those. They're in the bundle at page 577. And if we rely first of all on the recitals, we rely on the recitals for two principal reasons. First, because the recitals contain expressions of concern about varying standards of compliance, and second, because they're relevant to the appellant's argument concerning proportionality. So if I may try to explain what we mean by that. First of all, recital, we rely on page 577 because of the common minimum rules point for the protection of animals. Recital 2 is the provision that makes it clear that business operators and any person involved in the killing must take the necessary measures. We do not accept that recital 2 is setting out a requirement for intention or negligence to operate as an essential component of the regulatory breaches. It is merely illustrative of how avoidable pain or suffering might be caused. And in any event, for reasons we've already outlined, negligence does not assist the appellant because it is not ordinarily regarded as a mens rea requirement. If your lordships wish to have the references to what the presumption of mens rea involves, sweet and parsley, it's addressed in the bundles at page 1403. B and DPP, Lord Nichols, at page 854 of the bundle, between letters C and E. Recital 3 makes clear that one of the deficiencies in the earlier regulation was the large discrepancies observed between member states in implementing the directive and major welfare concerns and differences susceptible to affect competitiveness. There is the harmonisation principle being explained on the problems that had been met historically. Recital 5 is...
Perry, Lord Burrows has a question for you.
I'm sorry, my lord, yes.
Mr. Perry, just before we go over it at this rate of pace, you may be coming back to this, but recital 2, on the face of it, doesn't look as if it's illustrating, I think you said, examples where there may be intentional negligence, as if they were examples of where that may occur. Wouldn't you accept that on the face of it, it does seem to impose something much more than that?
Well, my lord, for this reason, my lord, no. Principally for this reason. First of all, it's not part of the actual requirement in either in Regulation 3 or in Regulation 15, and we don't accept that this is incorporating into the breaches of the regulation concepts such as negligence or intention. And for the reasons that I've already explained, negligence would not assist the appellant's arguments, because that does not connote a particular state of mind. It can connote a failure to conform to a particular standard.
But I think they would argue against that they are willing to accept that they're not saying, as I understand it, that there is mens rea in what you're classing as the classical sense of intentional recklessness. They only need to go as far, as I understand it, as showing that there is a requirement of negligence. And these words do seem to, on the face of it, to import that, don't they?
Well, but Lord, I would submit that the language of the actual regulations that impose the requirements make clear that there is no requirement to establish either negligence or intention, and that liability is strict for the reasons which are set out in the recitals read as a whole, and in the particular the particular provisions which carry the obligations, in particular Regulation 3, Regulation 15, read with Annex 3.
But Regulation 3 uses the word avoidable, and isn't
Yes.
this recital 2 indicating what we are to understand by avoidable?
Well, my Lord, what I would submit is that we fully accept that where that it is addressing avoidable pain, but the avoidable pain is explained by the obligation to conform to the strict requirements of the particular regulations. There isn't scope for reading into this some due diligence or negligence-based defence, because that is simply not is what the regulations read as a whole incorporate into this scheme. And if it were, and if that were the position, then what is intended to be a coherent, easily applicable scheme does become less coherent and more difficult to apply.
Lord Burroughs, I think, is, let me say so, right in suggesting that recital 2 is helpful in assisting us to understand what's meant by avoidable pain and suffering. In the first sentence, recognizes that killing animals may induce pain and so forth, even under the best available conditions. So there cannot be strict liability simply for inducing pain.
Yes.
Liability can only be for inducing pain which is avoidable.
Yes.
And so it then goes on to say, that in the last 6 lines, that pain, distress or suffering should be considered as avoidable when business operators or any person involved breach one of the requirements of this regulation or use permitted practices without reflecting the state of the art, thereby inducing, by negligence and so forth, suffering. So one would expect, reading the recital, one would expect to find liability being imposed either for failing to follow the requirements of a regulation or using a permitted practice, but not in a manner which reflects the state of the art.
Yes.
Now, if one now in the present case, we're concerned with a failure, a breach of one of the requirements of a regulation. It's a failure to follow the practices in Annex 3.
Yes.
And well, as I read recital 2, that would be enough.
Yes.
To render the pain and suffering avoidable.
Yes, and your Lord's reading is consistent with the way that the divisional court read it.
Mm-hmm.
which was that there are two limbs here.
Yeah.
One is the first limb, which is the breach of the requirements of the regulation, and the second limb, which is the use of permitted practices without reflecting the state of the art, which is then subject to the inducing by negligence or intention pain, distress or suffering of the animal. So they're two distinct components.
Yes. Yes, I'm not sure it's necessary to read the thereby clause as only applying to a failure to reflect the state of the art, because if there was a breach of one of the requirements laid down in the regulation, I mean, if we're talking, if it's envisaging the what it calls earlier in recital, the best available technical conditions and techniques, then if it's a failure, it is going to be either the result of negligence or of intent, not necessarily on the part of a business operator at all, but on somebody's,
on somebody's part.
Somebody's part. Yeah. Well, I wonder if perhaps we should continue this discussion after the adjournment.
Thank you very much, my lord. Yes,
thank you.
Thank you.